There are changes to these contracts which will add to your administrative burden. Clause 4.1.2, I think it is, not 4.12, but 4.1.2, sets out a new category of documents which you are required to maintain. I think you would be maintaining these documents anyway, but it's a new category of documents. You have to maintain wage records in respect of all workers. Now, as we've heard before and as we understand, clause 5.3 and section 5 of the document altogether has a very broad definition of the word workers, which includes not only the people who work for the main contractor, but all of the people who work for all of the subcontractors. So what you as a main contractor have to do, and what you as a principal subcontractor have to do, is make sure that everybody working underneath you is fixed with the same obligation to keep these records. Because if you don't do that, and somebody comes knocking and looking for them, you're going to be in breach of contract, and you're going to be the one who suffers the penalty for being in breach of contract. And there are penalties all over this contract for failing to comply with these procedures. It is necessary for main contractors and senior subcontractors to ensure that everybody in the chain beneath them has the same obligations, which is why it's so important to actually have formal subcontracts from top all the way down. Because if you can't impose these obligations on the people underneath you in the chain, you can't rely on them to produce the documentation that you need to produce to comply with your own obligation going up the line. 5.3.9 introduces in a formal way an obligation that you've always had, which is that if a representative of a trade union has a concern in relation to a registered employment agreement, then you have an obligation to talk to them. You have an obligation to appoint somebody who will be the representative of your organisation to whom this particular individual can speak. And that's now a contractual obligation. The really odd one is introduced by clause 5.7, which requires that every Monday morning you have to submit records with regard to the hours worked for every worker who's working on your site. So every Monday morning you have to bundle this stuff together and get it off to the employer's representative, who I'm sure would really want to get it every Monday morning, but there you go. On a serious note, this additional information that you are required to keep and maintain, and which you would be keeping and maintaining anyway, adds still further to the information available to an employer or an employer's representative when dealing with your claims. Now, it is provided to him for a particular purpose, which is to comply with these clauses. And these clauses are put there in order so that the contracting authority can satisfy itself that all the registered employment agreements are being dealt with and that people are being paid properly and pension contributions are being made. So if it is used for a different purpose, you might find that objectionable, and understandably so. But this all adds to the information, the pool of information that's available to the contracting authority in dealing with their project and your conduct of their project. The position with regard to concurrent delay is strengthened. If a delay has one or more causes, one of which is a contractor culpable delay, then there will be no extension of time. It gets rid of what's established legal authority, which is in most projects, in most cases that have come before the courts will take the time to figure out what is the dominant cause of delay. This clause specifically says, and it's not new, it was there already, but this clause specifically says that if there are several causes of delay and the contractor is responsible for one of them, then there will be no extension of time. Contra proferentum is removed. Contra proferentum is a principle of law which says that if there is an ambiguity in a contract, if there's an ambiguity in a contractual provision, one of the ways that the court can use to resolve that ambiguity is by saying, the particular clause will be construed against the person who drafted it. In this case, the contracting authority. Now, there is a specific removal of that principle. This contract says that no negative impact can result from the fact that we drafted this contract. Okay? So contra proferentum is removed. It's not the biggest deal in the world. In the first place, there are very few ambiguities in this contract. They're so well drafted, they are so clearly drafted, that finding an ambiguity in the contract is an extremely difficult thing to do. Once you have found it and are seeking to have that ambiguity resolved in your favour, contra proferentum is only one of the tools that an arbitrator, a conciliator or a judge can use in order to resolve that ambiguity. There are all sorts of other methods of resolving ambiguities. However, contra proferentum was a kind of a baseline of last resort for lawyers, and it is now removed from this contract. But as I say, it's not the end of the world. The insurances, as we know, and those are already stated, insurance changes have been introduced as a result of consultation with insurers. To my mind, they appear to be positive, but I would urge everybody to have the new clauses checked by brokers who would be able to adjust policies or adjust requirements in order to reflect these new changes. The definition of lands made available is changed. I think the purpose of this change is simply to clarify that when you are awarded a contract, when you actually go on site, you will be permitted from the start date to occupy an area of that site, which is the area actually provided by the employer. It won't necessarily be the entire of the site. Again, that hasn't changed. That was the position under the version number 1. You'll recall that under the traditional contracts, once you were appointed as contractor, you had a license to occupy that site from the employer, and you were entitled to have an exclusive license. So you could exclude everybody else, including the employer, whilst you were licensed to occupy that site. That all changed in version 1 of this contract. The purpose of this change is, as I say, to clarify what is meant by the area provided by the employer, the area that you are actually going to be entitled to occupy. The clause says that you are required to keep the area provided by the employer free from trespassers, which would appear to imply that your obligation to keep the site free from trespassers has in some way diminished, that your obligation has become less onerous. I'm not convinced that they've actually carried it through properly, because Section 7 of this contract is the section which actually deals with your obligations with regard to the site and with regard to the area provided by the employer. You have very substantial obligations with regard to the site, with regard to providing access across it, with regard to site security. And I think a step has been missed here. Whilst there is an intention to diminish your obligation to a certain extent, I don't think it's carried through properly. And the bottom line is that whilst you might only be entitled to occupy the area provided, you have very substantial obligations with regard to the balance of the site as well. And I think I would encourage everybody to read Section 7 of the contract very carefully to understand what those obligations are.